The following statements regarding fundamental right to reside and settle in any part of the territory of India. Statement 1, it is guaranteed only to citizens of India. This is correct because Article 19 are available only to the citizens. Second statement, it is subject to reasonable restrictions that can be imposed in the interest of only scheduled tribes. This is not correct because restrictions can be in the interest of the general public or the protection of the interest of scheduled tribe, not only scheduled tribe. Third statement, reasonable restrictions can be imposed only by a law enacted by the parliament after the commencement of the constitution. This is also incorrect because restrictions can be imposed by any valid law, including state laws, not just parliament. Therefore, the answer would be B1 only. 76. A person to be eligible for election as the Vice President of India should, statement 1, be a citizen of, correct. Statement 2, have completed the age of 35 years, correct. 3, be qualified for election as a member of the Council of State, correct. Article 66(3) of the Constitution says that a person is eligible for election as Vice President if they fulfill all these three criteria. Therefore, the answer would be D, all three are correct, 1, 2 and 3. 77. Consider the following statements regarding fundamental rights guaranteed under Part 3 of the Constitution of India. 1. Right to freedoms guaranteed under Article 19 can be suspended in certain cases. Correct, because these are suspended during emergency declared on grounds of war or external aggression, and this is provided under Article 358. Second statement, all fundamental rights can be suspended in certain cases. Incorrect, because the enforcement of Article 20 and 21 cannot be suspended even during an emergency under Article 359. So this is incorrect. Third statement, protection in respect of conviction for offences cannot be suspended. Absolutely correct, because Article 20 provides protection in respect of conviction and therefore it cannot be suspended. Therefore, option C, 1 and 3 only will be correct. 78. Which one of the following statement is not correct? Title of academic distinction can be conferred by the state on any person. Correct. A citizen of India shall accept any title from any foreign state. Correct. No person in India shall accept any present, emoluments or office of any kind from any foreign state. This is not correct because it is too broad. Because Article 18 subsection 4 states no person holding any office of profit or trust under the state shall without the consent of the president accept any present. Now, in this option, it omits the crucial condition of holding office of profit, implying that even a private individual cannot accept a present, which is false. Therefore, this one is incorrect and therefore answer to this question. Let's read the other option. No person who is not a citizen of India shall accept any title from any foreign state without consent of the President of India while holding any office of profit or trust under the state. This is correct. Next, 79. The Constitution of India envisages minimum wage or living wage or fair wage or maximum wage. The answer is living wage. This is provided under Article 43 in DPSP, Directive Principles of State Policy. It states that the state shall endeavor to secure a living wage for all workers. 80. Which one of the following statements is correct? The Council of State shall consist of not more than 238 members. This is incorrect because the maximum strength is 250, which includes 238 representatives plus 12 nominated ones. Second, all the members of the Council of States are elected by the members of legislatures of state. This is again incorrect because 12 are nominated, not elected by state legislatures. C, the representatives of union territories are chosen by the administrator of the union territories concerned. This is also incorrect because union territory representatives are chosen in a manner as Parliament may by law prescribe, not by the administrator. D, 12 members can be nominated by the President of India to the Council of States having special knowledge or practical experience in literature, science, art and social service. This is correct and this is provided under Article 8. 81. The President of India does not have power to grant pardons, reprieve, respite or remissions of punishment in which of the following cases? A, in all cases where the punishment or sentence is by a court-martial. This is incorrect because President has the power. This is provided under Article 72 subsection 1 subclause A, that President's pardoning power under Article 72 covers sentences by court-martial. B, in all cases where the sentence is life imprisonment. This is correct because if a person is sentenced to life imprisonment for an offense under a state law, for example, a standard murder case under the IPC or a BNS, where executive power lies with the state, the president does not have the power to pardon. The power lies with the governor under Article 161. The president only has concurrent power if it is a death sentence. Therefore, option B is correct. Case where president's power is not absolute or universal unless it falls under union jurisdiction. Next, C, in all cases where the sentence is a death sentence, this is covered. President has the power under Article 72, subsection 1, clause C. The president's pardoning power covers sentences of death. D, in all cases where the sentence or punishment is for an offence against any law relating to a matter to which the executive power of the Union of India extends. Incorrect, because President has the power under Article 72, subsection 1, clause B, that President's pardoning power also covers offences against laws where the Union's executive power extends. Therefore, the answer would be B. The grounds and procedure for removal of which one of the following is different from the rest? Judge of the Supreme, B, Judge of a High Court, C, Comptroller and Auditor General of India, D, Election Commissioner. The answer would be Election Commissioner, because judges of Supreme Court or High Court and the Comptroller and Auditor General are removed by an order of the President after an address by each House of Parliament supported by a special majority on grounds of proved misbehavior or incapacity. This is provided under Article 124, Clause 4, Article 217 and Article 148 respectively. But an Election Commissioner, other than the Chief Election Commissioner, does not enjoy this constitutional protection. They can be removed by the President on the recommendation of the Chief Election Commissioner, and this is provided under Article 324, Clause 5 proviso. Therefore, their removal procedure is different. 83. Courts are barred from examining the validity of any law relating to elections or to either House of Parliament dealing with 1. Allotment of seats to various constituencies, correct. Delimitation of constituencies, correct. Preparation of electoral rolls, incorrect. Article 329A of the Constitution bars courts from examining the validity of any law relating to, first, to delimitation of constituencies and allotment of seats to such constituencies. The preparation of electoral rolls is not protected under 329A from judicial scrutiny regarding the validity of the law itself through Article 329B, though Article 329B bars questioning an election except via election petition. Therefore, the answer would be B, 1 and 2. 8. Consider the following statements with regard to bills. 1. A bill pending in Parliament shall not lapse by reason of the prorogation of the Houses of... Correct. Prorogation means ending of session. Ending a session does not lapse a pending bill. This is provided under Article 107, Clause 3. Second statement, a bill pending in the Council of States which has not been passed by the House of the People shall not lapse on dissolution of the House of the People. This is also correct, because a bill pending in the Rajya Sabha that has not been passed by the Lok Sabha does not lapse on the dissolution of Lok Sabha, and this is provided under Article 107, Clause 4. Third statement, a bill having been passed by the House of the People is pending in the Council of State shall lapse on dissolution of the House of the People except as otherwise provided under Article 108 of the Constitution of India. This is also correct, because a bill passed by the Lok Sabha and pending in Rajya Sabha lapses on dissolution. This is provided under Article 107, Clause 5, unless a joint sitting was notified prior. This is provided under Article 108. Because 107 Clause 5 provides that a bill passed by the Lok Sabha and pending in Rajya Sabha lapses on dissolution, and 108 provides that unless a joint sitting was notified prior. Therefore, option D will be correct. Which of the following statements with regard to estimates is not correct? A. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of India shall not be submitted to the vote of Parliament. This is correct. B. No discussion is allowed in Parliament on the estimates relating to expenditure charged upon the Consolidated Fund of India. This is incorrect, because Article 113, Clause 1 states that while charged expenditure is not submitted to the vote of Parliament, nothing prevents the discussion on such estimates in either house. Other options: C. So much of the estimates as relates to other expenditure shall be submitted to the House of the People. This is correct. D. No demand for a grant shall be made except on the recommendation of the President of India. This is also correct. Therefore, the answer would be B, which is not correct. 86. Joint sitting of both houses of Parliament is permissible under the Constitution of India in which of the following cases? A. To consider a bill passed by the House of the People but rejected by the Council of States. This is correct. Article 108 allows for a joint sitting to resolve a deadlock if a bill is rejected by the other house, the houses finally disagree on amendments, or more than 6 months elapse without the bill being passed. B. To consider a proclamation issued under Article 356 of the Constitution. This is not correct. To consider an address for the removal of Chief Election Commissioner. This is incorrect, because impeachment or removal does not use joint sittings. D. More than 3 months have lapsed from the date of reception of the bill by either house without the bill being passed by it. This is incorrect, because the time period is 6 months, not 3. 87. Which one of the following statements is not correct? A. No person can be deprived of his property without authority of law. This is correct. B. A law enacted by Parliament providing for acquisition of any land held for the purposes of agriculture shall be void on the ground that the same is inconsistent with fundamental right to equality. This is incorrect, because 31A of the Constitution specifically saves laws for the acquisition of estates, including agricultural land, from being declared void on the ground that they are inconsistent with Article 14, that is equality, or Article 19. C. No tax shall be collected except by authority of law. This is also correct. D. The freedom to carry on trade, commerce and intercourse throughout the territory of India is not absolute. This is also correct. 88. The Constitution of India does not prescribe minimum number of members to the Legislative Assembly of Goa or Delhi, Mizoram, Arunachal Pradesh. B. Delhi is the answer. Article 170 sets the minimum Legislative Assembly size for states at 60. Specific exceptions exist for states like Goa, that is minimum 30, that is provided under Article 371I, and for Mizoram, Article 371G provides that the minimum number should be 40. Delhi, being a union territory, is governed by Article 239AA, and the size of its assembly, 70 seats, is determined by Parliament via the GNCTD Act, not by constitutional minimum floor applicable to states. 89. Which of the following statements with regard to the creation of an All India service is or are correct? 1. An All India service can be created only by law enacted by Parliament. This is correct because Article 312, Clause 1 empowers Parliament to create All India services by law. 2. An All India service can be created only in national interest. This is correct. The Rajya Sabha must first pass a resolution declaring it necessary or expedient in the national interest. 3. An All India service shall include all judicial posts in the subordinate judiciary. This is incorrect because Article 312 Clause 3 states the All India Judicial Service shall not include any post inferior to that of a district judge. Therefore, option B is correct, that provides 1 and 2 only. With respect to election to state legislatures, which one of the following statements is not correct? A. The legislature of a state has power to make law with respect to all matters relating to elections to either house of the legislature. This is correct. The legislature of a state has power to make law with respect to preparation of electoral rolls relating to elections to either house of the legislature. This is also correct. The legislature of a state has absolute power to decide the total number of seats in the legislative assembly and the territorial constituencies. This is not correct. The total number of seats and territorial constituencies are determined by the Delimitation Commission under an Act of Parliament under Article 170. The state legislature does not have absolute power over this. It is subject to the Constitution and central laws. D. The power of the legislature of the state is subject to a law made by Parliament. This is also correct. Therefore, the answer would be C. 91. Which one of the following statements is not correct? A. The President of India or the Governor of a state shall not be answerable to any court for the exercise and performance of the powers and duties of his office. This is correct. B. The conduct of the President may be brought under review by any court or body appointed by either House of Parliament for investigation of a charge under Article 61 of the Constitution of India. This is also correct. C. A criminal proceeding can be continued against the Governor of a state during his term of office if the same had been instituted prior to his appointment as Governor. This is not correct because Article 361(2) grants immunity to the President and governors. It provides that no criminal proceedings whatsoever shall be instituted or continued against the President or the Governor of a state in any court during his term of office. Therefore, this is incorrect. D. No process for the arrest of the President or the Governor of a state shall issue from any court during his term of office. This is also correct. 92. The Constitution of India protects publication of proceedings of Parliament in which one of the following cases? A. Publication of substantially true report of any proceedings in a newspaper. B. Broadcasting of a substantially true report of any proceedings by means of wireless telegraphy, etc. C. Publication of any true report of any proceedings. D. Publication or broadcasting of a substantially true report of any proceedings except the secret sittings of either house in a newspaper without malice. This one is correct. Article 361A that was added by 44th Amendment provides constitutional protection to the publication of substantially true reports of proceedings of Parliament or state legislature in newspapers or radio or TV, provided the publication is without malice and the proceedings were not a secret sitting. 93. Consider the following statements with regard to the office of the Vice President of India. 1. The election of the office of the Vice President must be held within 2 months after it falls vacant by reason of his or her death, resignation or removal or otherwise. This is incorrect. There is no 2 months time limit for VP elections in the Constitution, unlike the 6 months for President. Article 68 Clause 2 says as soon as possible. 2. A member of the House of the People, after having been elected as Vice President, shall be deemed to have vacated his seat in the House of the People on the date of his election as Vice President. This is incorrect. Article 66 Clause 2 states a member is deemed to vacate his seat on the date he enters upon his office, not the date of his election. An election to fill a vacancy caused by the expiration of the term of the office of Vice President shall be completed before the expiration of the term. This is correct. Article 68 Clause 1 mandates that the election to fill a vacancy caused by the expiration of the term shall be completed before the expiration of the term. Therefore, only option 3 is correct, C. 94. Subject to other provisions of the Constitution of India, the executive power of the Union of India shall extend to 1. The matter with respect to which Parliament has power to make law, excluding matters with respect to which the legislature of the state has also power to make laws. This is correct. Article 73 defines the extent of the union power. It extends to matters where Parliament has lawmaking power, subject to the proviso that it does not extend to concurrent list matters in states unless expressly provided. Second statement, the exercise of such rights, authority, and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement. This is also correct. It does extend the exercise of rights or authority from any treaty or agreement. Therefore, both option 1 and 2 would be correct, C would be correct. 95. Which one of the following statements is correct? A. The Constitution of India does not contain any special provisions with regard to the state of Maharashtra. This is wrong because Maharashtra has Article 371. B. The grounds and procedure for removal of an election commissioner is different from the one prescribed in the Constitution of India for the removal of a member of the UPSC. This is correct because election commissioners other than Chief Election Commissioner are removed on the recommendation of Chief Election Commissioner that is provided in Article 324. Article 317 provides that UPSC members are removed by the President after a Supreme Court inquiry. C. Article 370 of the Constitution of India has been repealed. This is technically imprecise because Article 370 was modified, not repealed. D. The Constitution of India contains express provisions for the suspension of an election commissioner. This is also incorrect. So the correct answer would be B. 96. In which one of the following judgments did the Supreme Court decide on the constitutional validity of Section 5 of PMLA 2002? It was B. Vijay Madanlal Chaudhary versus Union of India that was decided on 27 July 2022. The Supreme Court had upheld the constitutional validity of PMLA, including the stringent bail conditions that has twin conditions and powers of arrest or attachment that is provided under Section 5. 97. X, a director appointed under the PMLA 2002, has reason to believe that Y was guilty of committing an offence punishable under the said Act. Which one of the following is not correct regarding the powers of arrest under Section 19 of the Act? A. X must record the reasons for his belief in writing in order to arrest Y. Correct. Therefore, this is not the answer because it is asking which is not correct. B. X shall inform Y as soon as may be the grounds of arrest. This is also correct. C. X may arrest Y but shall first inform the adjudicating authority about the same. This is not correct because under Section 19 of PMLA, the arresting officer must forward a copy of the order and material to the adjudicating authority immediately after the arrest. There is no requirement to inform the authority before making the arrest. D. Y must be taken before a special court or judicial magistrate or metropolitan magistrate having jurisdiction within 24 hours. This is also correct. Therefore, the answer would be C. X was found to be in possession of forged banknotes in circulation and a diary containing the details of all such notes in his own handwriting. Under the PMLA, which one of the following presumption is or are correct? 1. The forged banknotes and the diary belong to X. Correct. 2. The contents of the diary are true. Correct. Section 22 of PMLA creates a statutory presumption for records or property found in possession of a person that they belong to such person and that the contents of such records are true. Therefore, the answer to this question would be both 1 and 2, option C. A villa located in New Delhi was provisionally attached by a deputy director appointed under the PMLA 2002. The adjudicating authority under Section 8 confirms the attachment. Consider the following statements. 1. The attachment shall continue during the investigation subject to 180 days. This is incorrect because the provisional attachment is for 180 days once confirmed by the adjudicating authority that is provided in Section 8 subsection 3. It continues for 365 days or during the pendency of proceedings. It is not subject to the original 180-day cap. So this is incorrect. 2. The attachment shall become final after the provisional attachment has continued for 365 days. This is also incorrect because attachment becomes final only after the special court passes an order of confiscation at the conclusion of the trial that is provided in Section 8 subsection 5. This does not automatically by the lapse of time. Therefore, both the options are incorrect. The correct option would be D, neither 1 nor 2. Confiscated under Chapter 3 of PMLA 2002. Which one of the following is not correct regarding the powers of management of such property? A. The central government may appoint officers to perform the functions of an administrator. This is correct. The appointment of administrator must be made through an order that is published in the official gazette. This is also correct. The administrator is appointed by the director under the Act. This is not correct because under Section 10 of PMLA, the central government appoints the administrator to manage confiscated property, not the director of Enforcement Directorate. So this is incorrect and therefore the answer to this question. D. The administrator shall receive and manage the property. This is also correct. Consider the following statements under Prevention of Corruption Act 1988. 1. Any public servant who induces another public servant to forbear performance of a public duty in anticipation of accepting undue advantage from any person shall be punishable under the Act. Statement 1 is correct. Section 7A of Prevention of Corruption Act criminalizes the act of accepting undue advantage to influence a public servant by corrupt or illegal means or by the exercise of personal influence. 2. X abets Y, a public servant, to accept 50 lakh rupees over and above the application fee for granting him a liquor trade license immediately. Y, however, refuses to accept the same, X is not punishable under the Act. This is incorrect because under Section 8, bribing a public servant, the mere offense of promise to give an undue advantage constitutes an offense. Even if Y, the public servant, refuses, X is liable for the attempt or abetment to the Act. 3. X, a sub-inspector of police, is entrusted with some jewelry that was confiscated during an investigation. X plans with his brother to take one of the necklaces and sell it. However, X is not successful in executing the plan. X cannot be punished under the Act. This is incorrect because X's action amounts to criminal breach of trust or misappropriation by a public servant under Section 13 subsection 1 clause A. Under section 15 of Prevention of Corruption Act, the attempt to commit an offence referred to in section 13 subsection 1 clause A is punishable. Therefore, X can be punished despite the failure of the plan. Therefore, in this situation, option A will be correct, 1 only. 102. In Central Bureau of Investigation, Bank Securities and Fraud Cell versus Ramesh Gelli, 2016, the Supreme Court dealt with which one of the following issues under the Prevention of Corruption Act 1988? A. The members of parliament are to be considered as public servant. This is incorrect. Purchase of government property by a chief minister involves an issue of potential corruption. This was not discussed. A public servant can be prosecuted even after retirement for acts committed while in service. This was not discussed. D. Higher officials of private banks such as chairpersons or managing directors will be considered as public servant. This is correct. This was discussed. The Supreme Court held that managing directors and chairpersons of private banks are considered public servant for the purposes of Prevention of Corruption Act, read with 46A of Banking Regulation Act 1949. 103. X, a businessman, has applied to obtain a license for operating a cinema hall in the locality. Y, the public servant who is the dealing officer, compelled the payment of 1 crore rupees in cash over and above the prescribed fee for the license to be granted. X makes the payment but consequently posts the matter in the social media. Y immediately responds by stating that X has committed an offense relating to bribing of a public servant under Section 8 of the Prevention of Corruption Act 1988. A. X shall be punishable as his action is legally and ethically incorrect. B. X punishable as he did not report the matter to the law enforcement authority. This one is correct because Section 8 of Prevention of Corruption Act punishes the bribe giver. However, the proviso to Section 8 subsection 1 provides immunity if the person was compelled to give the undue advantage and reports the matter to the law enforcement authority or investigating agency within 7 days. Posting on social media does not satisfy the statutory requirement of reporting to the authorities. Therefore, X remains liable. Let's read the remaining options. C. X shall not be punishable as he was compelled to make the payment. This is not correct. X shall not be punishable as he brought the matter out in public. This is also not correct. Partner in a partnership firm which is formed in Singapore but also carries on certain business in India. For obtaining certain trade clearances, X visits the local municipal corporation and offers to pay a premium price on behalf of the firm if the officer agreed to provide the clearances immediately. In this situation, under the Prevention of Corruption Act 1988, A. X shall not be punishable as he is a partner of a firm formed in Singapore. B. Only X shall be punishable for offering bribe to a public servant and the partnership firm is not punishable. C. The offense of bribing a public servant will be considered to have been committed by the partnership firm. This one is correct because Section 9 of Prevention of Corruption Act deals with offense by commercial organizations. If a person associated with a commercial organization like partner X in this situation gives or promises to bribe or to obtain or retain business or an advantage, the organization itself is punishable with a fine. Here, X is also personally liable under Section 8. D. No offense is committed as only offer to make payment was made. The payment was not done. This is incorrect. 105. Which one of the following was not discussed by the Supreme Court in State of Lokayukta Police, Davanagre versus CB Nagaraj, decided on 19 May 2025? A. The factum of demand of bribe by a public servant must be proved beyond reasonable doubt. This was not discussed. B. The punishment in case of multiple proven case of bribe must fall under the purview of Section 14 of Prevention of Corruption Act. This was discussed. C. To invoke the presumption under Section 20 of the Prevention of Corruption Act, the demand of bribe must be proved by the prosecution. D. Mere recovery of tainted money is insufficient if the essential elements of demand is not conclusively proved. Option A, C, and D are established law, and these were also reiterated in judgments like Neeraj Datta versus State regarding demand, presumption, and recovery. But Section 14 deals specifically with enhanced punishment for habitual offenders, not necessarily for every instance of multiple bribes proved in a single trial unless prior conviction exists. Therefore, statement B is the outlier or incorrect discussion point in the context of standard proof of bribery judgments. Therefore, option B would be correct. 106. Which one of the following is not a power of CCI? A. Inquiry into acts taking place outside India affecting competition in India. Section 32 allows inquiry into acts outside India, so this one is a power of CCI. B, power to issue interim orders. This section 33 allows interim orders, so this one is also a power. C, power to review its own orders. This power CCI does not have because this power was removed by the 2007 amendment, and appeals against CCI orders lie with the NCLAT. D, to recover any monetary penalty from any person against whom penalty was imposed. Section 39 allows recovery of penalties, so this one is also a power. Only C is not a power, therefore this is the correct answer because the question is asking what is not a power. 107, which one of the following is not considered as an anti-competitive agreement under Section 3, subsection 4 of Competition Act 2002? Resale price maintenance, refusal to deal, exclusive distribution agreement, predatory pricing. The answer would be predatory pricing because Section 3, subsection 4 of Competition Act lists anti-competitive agreements, that is vertical restraints such as tie arrangement, exclusive supply or distribution agreement, refusal to deal, resale price maintenance. Predatory pricing is classified as an abuse of dominant position under Section 4. This is not an agreement under Section 3, subsection 4. 108, which of the following action has or have been treated as abuse of dominance under Section 4 of Competition Act 2002, where an enterprise or a group, directly or indirectly, imposes unfair or discriminatory condition in purchase or sale of goods or service? This one is correct, and it is covered under Section 4, subsection 2, clause A. 2, where there is a requirement that a purchaser of goods or services as a condition of such purchase to purchase some other distinct goods or services. While tie-in arrangements are also abuses, they are often associated with Section 3, subsection 4 in multiple choice questions. 3, where there is indulgence practices resulting in denial of market access in any manner. This is called denial of market access, and this is covered under 4, subsection 2, clause C. Under Section 4, which provides abuse of dominant position, 3 things are covered: unfair condition under Section 4, subsection 2, clause A, denial of market access, that is covered under Section 4, subsection 2, clause C, and tie-in arrangements as abuses. But since 1 and 3 are the core definitions of abuse, that is pricing or conditions and market access, D is the most appropriate here, that is 1 and 3. 109. The Competition Commission shall have regard to which one of the following factors while determining whether an agreement has an appreciable adverse effect on competition under Section 3 of Competition Act 2002? A, economic power of the enterprise including commercial advantages over competitors. This is incorrect. B, size and importance of the competitors. This is incorrect. Driving existing competitors out of the market. This is correct. Section 19, subsection 3 lists factors to determine appreciable adverse effect on competition for agreements under Section 3. These include this option, driving existing competitors out of the market. Factors like economic power in the first option or size of competitors, and the last option, market structure and size of market, these are listed under Section 19, subsection 4 for determining dominant position, not determining appreciable adverse effect on competition. The CCI shall not have regard to which one of the following factors while determining the relevant geographic market as per Section 19 of Competition Act. A, exclusion of in-house production. B, regulatory trade barriers. C, adequate distribution facilities. D, transport costs. Section 19, subsection 6 lists factors for determining relevant geographic markets, such as all these regulatory trade barriers, transport costs, distribution facilities. But the first option, exclusion of in-house production, that is captive consumption, is typically considered when determining the relevant product market under Section 19, subsection 7, or strictly as a market definition nuance. It is not a statutory factor listed under Section 19, subsection 6 for geographic market. Therefore, option A would be correct. 111. In order to ensure that an enterprise does not abuse its dominant position, the CCI may not provide which one of the following matters under Section 28 of the Competition Act 2002. A, the transfer or vesting of properties, rights, liabilities or obligation. B, the creation, allotment, surrender or cancellation of any shares, stocks or securities. C, the market share in the relevant market of the persons or enterprise in a combination, individually and as a combination. This one is correct. Section 28 empowers the CCI to order the division of an enterprise enjoying a dominant position. The order may provide for transfer of property as written in A, adjustment of shares as provided in B, and the last option, the amendment of the memorandum of association or articles of association or any other instruments regulating the business of any enterprise. This can also be there in the order. But option C refers to the assessment of market share, which is a factor of inquiry, not a remedial provision to be included in a division order. Therefore, since this is incorrect, therefore this would be the answer to the question, as it is asking, the question is asking what is not, what CCI may not provide. 112. The Supreme Court in CCI versus Scott Glass India Private Limited, decided on 13 May 2025, relates to which one of the following provisions of the Competition Act? It is related to abuse of dominant position. It is a leading case concerning Section 4 of Competition Act, dealing with discriminatory pricing and abuse of dominance in the glass tube market. 113. Whoever dishonestly or fraudulently make use of an electronic signature of any other person is punishable for which one of the following offences under IT Act 2000? Punishment for dishonestly receiving stolen computer resource or communication device? No. Punishment for identity theft? Yes. Section 66C of IT Act defines the punishment for one who dishonestly or fraudulently makes use of the electronic signature, password, or any other unique identification feature of any other person. This is titled punishment for identity theft. Therefore, this would be the correct answer. Not punishment for violation of privacy, not even punishment for cyber terrorism. 114. Under the IT Act, a person who, on behalf of another person, receives, stores, or transmits a record is considered to be an intermediary. This is correct because Section 2W defines an intermediary as any person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record. For example, telecom providers, ISPs, cyber cafes. 115. Which one of the following is not a ground for revoking a digital signature certificate by the certifying authority under the IT Act 2000? A. Where a material fact in the DSC is false or has been concealed? No. B. Upon the death of the subscriber? No. C. The subscriber holds a private key corresponding to the public key listed in the DSC. Option C is correct because this is a requirement for a valid digital signature certificate, DSC. This is not a ground for revocation. Under Section 38, certifying authority may revoke a DSC if the subscriber has died, the firm is dissolved, a material fact is false, or the key is compromised. If the subscriber holds the key securely, the DSC remains valid. The last option D, the certifying authority's private key was compromised, is also not correct. 116. Consider the following statements in respect of the Appellate Tribunal under IT Act 2000. 1. The provisions of the Limitation Act 1963 shall as far as possible apply to the appeals made to the Appellate Tribunal. This is correct. It is provided under Section 57, subsection 2 of the IT Act 2000 that Limitation Act 1963 applies to appeal. 2. The Appellate Tribunal established under the Telecom Regulatory Authority of India Act 1997 is to be the Appellate Tribunal for the Act. This is also correct. The TDSAT, Telecom Dispute Settlement and Appellate Tribunal, acts as the Appellate Tribunal for the IT Act. This is provided under Section 48. The Appellate Tribunal shall not be bound by the procedure laid down by the CPC. This is also correct. And this is provided under Section 58, and it states that the tribunal is not bound by the CPC but by the principles of natural justice. Therefore, all the options are correct, 1, 2, and 3. The answer would be A. 117. Critical information infrastructure means a computer resource, the incapacitation or destruction of which shall not have debilitating impact on which one of the following? A. National security, B. Public health, and C. Traffic data, D. Economy. C. Traffic data would be the answer. Section 70 defines critical information infrastructure as a computer resource, the incapacitation or destruction of which would have a debilitating impact on national security or economy, public health, or safety. Traffic data is not a category of impact listed in the definition of critical information infrastructure. 118. Which one of the following is not a reason for which the central government may authorize to monitor and collect traffic data under Section 69B of the Information Technology Act 2000? A. To enhance cybersecurity. B. For identification, analysis, and prevention of intrusion. C. Spread of computer contaminant. D. Maintain friendly relations with foreign states. The answer would be D because Section 69B authorizes the monitoring and collection of traffic data for specific purposes, that is cybersecurity, identification or analysis or prevention of intrusion or computer contaminant. Maintenance of friendly relations with foreign states is not a ground for blocking access under Section 69A or interception under Section 69, but it is not a ground for collecting traffic data under Section 69B. A cyber cafe owner is asked to provide subscriber information to a law enforcement agency. According to the Information Technology Act 2000, what is the owner's legal obligation? A. Extend all facilities and technical assistance to the agency. Correct. B. To obtain the user's consent before providing any information under Section 67C of the Act. No, it is not correct. To provide the information based on Section 69A of the Act. No. To provide the information based on the orders of controller as per the Section 68 of the Act is not correct. Under Section 69 and generally for intermediaries, the legal obligation when a direction is issued by a competent authority is to extend all facilities and technical assistance to provide access or intercept the information. 120. Under 3 subsection 2 of the IT Act 2000, the authentication of electronic records cannot be effected by use of A. Asymmetric crypto system and use of a public or private key, asymmetric crypto system and hash function, asymmetric crypto system and hash result, asymmetric crypto system and algorithmic mapping. This one is the correct answer, D. Section 3 subsection 2 of the IT Act specifically defines the authentication of electronic records by a digital signature as being effected by the use of an asymmetric crypto system and hash function. Option D. mentions algorithmic mapping, which is not the statutory terminology used to define the authentication process in this section. Therefore, since the question asks what cannot be affected, the answer would be asymmetric crypto system and algorithmic mapping.